In today's iteration of the Rockefeller College election series, we are joined by Julie Novkov. So Dr. Novkov is the Dean of Rockefeller College. She has taught here as a professor in political science, as well as in women's gender and sexuality studies. Relevant for our purposes, she's taught a number of courses in public law and in constitutional law. Dr. Novkov has been recognized for her teaching excellence and contribution to the Albany community with being awarded the Collins Fellowship. Before I give Dr. Novkov the floor here, as always, we're just going to go through the ground rules in case anyone's new here. So if you have any questions for Dr. Novkov over the course of her presentation today, you can put those in the comment section, and I will read those comments once we get into the Q&A section. Alternatively, you can use the hand raise function, and I'll also try to call on you. With that being said, we can pass it over to Dr. Novkov.
Thank you, Connor, for that generous introduction. And thank you, of course, to Renee and Rockefeller College staff who have helped to make this series a great success. And thank you to all of you who've decided to spend a little time during lunch learning about where we are with the Supreme Court as the new term gets fully underway. We are just past the first Monday in October, so the court has already heard some oral arguments and they have a big term looking ahead. What I'm going to do is talk just a little bit about where the court is, glancing back at the 2023 term. And then I'm going to talk about some of the cases that are currently slated for consideration during this term. And then I'm going to try to give you a little bit more of a big picture view of what's going on with the court and what we might be able to expect. This is going to be a bit of a spoiler alert, but some of what happens with the Supreme Court this year is going to depend on what happens with the election in November. But the Supreme Court may not be a passive participant in what happens in November. So with that groundwork laid, let me just talk a little bit about how we got to the fall 2024 term and how that sets up what's probably going to happen this term. So if we look at what the Supreme Court has been doing in recent terms, we have seen them issuing a smaller number of rulings on the merits. They used to be pretty reliably up into that 70, 80, or even higher number of cases that they would consider as a full court and produce full rulings on the merits. But in the last few years, that number has been declining. There were only 60 rulings on the merits in the 2023 term. There were 57 in 2022, 66 in 2021, and 67 in 2020. However, the rulings that they've been issuing, as I'm sure you know, if you've been following the court, have often had quite significant consequences. So we certainly can't look at that small number and say that the court has become less important or influential. It's certainly been quite influential and important. And in the last term, they released some decisions that produced some controversy. They produced a few decisions about the administrative state. There was the Jarchese case, which ruled that for SEC violations that had significant civil penalties attached, individuals had the right to a jury trial if they wanted it, which upended many, many years of administrative practices. There was, of course, the reversal of Chevron deference, or the idea that the federal courts need to defer to agency interpretations of statutes. They are now putting themselves in the center of that process. And then there was a less noticed case, Corner Post, which determined that when a business or organization suffers an alleged injury from an administrative rule, the statute of limitations for challenging that rule begins with the injury rather than when that rule was passed, which could, when you think about it, render vulnerable administrative rules that have been on the books since the 1940s or the 1950s. So those are some significant rulings. There was the net choice ruling that revived First Amendment challenges to attempts by the states of Florida and Texas to impose a particular set of internet regulations. People probably also note the AFT's attempt to classify bump stocks as machine guns and then subject them to further regulation was rebuffed by the court. There was a little bit of development on abortion. Some people were expecting the court to maybe double down on what it had done in Dobbs. We actually did not see that. The court had accepted an Idaho case that pitted a federal rule, a federal law mandating emergency services for reproductive crises against an Idaho statute that banned abortion. The court accepted that case, but then at the last minute decided that they were not going to rule in that case. And the court declined an invitation from the Fifth Circuit to basically pull back approval for mifepristone under an FDA review process. People would also note the controversial ruling on camping outdoors as a violation of freedom. The court ruled that states and localities can impose and enforce these kinds of requirements. The court, however, also waded into some controversies that were not only political, but had strong partisan valence. These, of course, are cases that had to do with former President Donald Trump and with the January 6th insurrection. In the Fisher case, the court determined that the federal statute that had been used to charge some of the January 6th defendants did not extend to the extent that the prosecution had used it. And the court, of course, ruled that states could not use Section 3 of the 14th Amendment to keep Trump off the ballot. And then the last case that they released in the summer was the ruling on Trump immunity, which basically caused Jack Smith and the January 6th to go back to the drawing board and sort through the things that that Trump had done that could be considered under that ruling to have been unofficial acts. And what we've seen with these cases is that there's a continued divide on the court that has fallen out, not just on ideological grounds, but on partisan grounds as well, with you have the three liberal justices who were appointed by Democratic presidents, and then 6 justices who were appointed by Republican presidents, including 3 who were appointed by President Trump. So that's kind of where we are as we come up to the 2024 term. So what are we going to see? It doesn't look to me like the court is going to be working any harder this term than they have in the last few. They have set 9 cases for argument in October. They have 7 set for argument, up to 25 more cases that are not yet scheduled for argument, which is a total of 51 cases. They will likely go up from there. There are some issues that they will undoubtedly have to take on. So we will see more potential for major rulings as the term evolves, but that's where they are as a baseline to start with. Some of the cases that are already on the docket look to be either fairly consequential or fairly influential, or perhaps both. One of the first cases that they have already had argued before them is a case in which the government is attempting to regulate so-called ghost guns, or guns that are assembled with kits and don't have the kind of tracking information available to them, serial numbers that would be available on a gun that is produced by a manufacturer. Advocates for the Second Amendment do not want these guns to be subject to regulation, so the court is going to have to sort out that question. For the first time in some time, it looks like there is a possibility of a major ruling on the death penalty that is on the court's regular docket as opposed to an emergency petition. This continues the long saga of the Glossip case. In this case right now, the prosecutor and state attorney general agree that another look is warranted at this case, but the state court wants to proceed with the scheduled execution of Timothy Glossop, and the court has accepted this case basically to sort through under what circumstances a new trial can be ordered based on who is asking for it and what the circumstances are. There are some cases coming either under statute or under the Constitution itself. The court has scheduled argument, or has not yet scheduled, but is going to be hearing a case directly on trans rights. This is an equal protection challenge to Tennessee's restrictive Senate Bill 1. It is also, I would note, the first big gender equal protection case that the court has heard in some time. So it'll be interesting to see the direction that goes without Ruth Bader Ginsburg as a justice. There is a disability rights statutory case on the docket, which questions whether a former employee can sustain a suit under the Americans with Disabilities Act for discrimination. There's a freedom of speech challenge on the docket questioning whether a court that applied rational scrutiny to an adult have strict scrutiny. But I would warn people again that the cases that are grabbing all the headlines are not the only ones to watch. There is a case that's a little bit more under the radar, looking at a civil rights deprivation suit brought under federal section 1983. This is a statute that can be used to go after state actors who violate people's rights under color of state law. And there's a question, do they have to go through the entire administrative process at the state level before they can take that step? The court will be considering what burden of proof employers have to satisfy if they want to say that they are exempt from the provisions of the Fair Labor Standards Act. Is it going to be a lighter burden, which lets them really, or are they going to have the tougher standard to meet there? And then the administrative state remains on the docket. I know you thought we were done after Chevron was reversed, but we are not done, not in any way, shape, or form. There's a challenge to the Clean Water Act, and specifically whether the EPA can enforce a rule that punishes discharges that violate water quality standards without specifying the limits to which those discharges must conform. There's also a question about the National Environmental Policy Act and whether that act authorizes an agency to study environmental impacts more broadly, rather than just looking at things that are directly affecting things that the agency can regulate. And the first case is to help us understand what it means that Chevron deference no longer exists, because the FDA's interpretation of exercise. This, but Pride Point students have been paying attention to. We are going to have more voting over mail-in voting, and the Republican Party has been in North Carolina. There's a question as a process whereby people said their ballots had problems and have the opportunity to fix them. That is under challenge. Michigan is having a challenge about their process for verifying voter signatures. And the ones I really think we should be keeping a close eye on, servers. There's pushback on that, but if that is upheld, it may bounce up and down from the Supreme Court. And then I expect that states that have been disrupted by recent tragic and chaotic weather events may try to put into place some accommodations that then will likely face legal challenges. And then there will probably be post-election challenges. And many of these are going to come up to the Supreme Court on their emergency docket. Some of them may come up as regular cases as well. Speaking of the emergency docket, this is again a year when we need to pay attention to the cases that are being as petitions or cases where they are looking to intervene before the case has gone through the process. As you might note, there were several challenges to EPA rules that were just recently rejected by the court, letting those rules go into place. But there are several new petitions on the emergency docket challenging EPA rules on oil and natural gas emissions, air pollution, and mercury. And there are currently 7 requests challenging an EPA rule that limits power plant emissions. So the court will have to take action on these cases as well. So despite the small number of cases, I think we can agree that it's going to be a busy term, and it looks like it again has the potential to be a big term where the court is doing things that will attract a lot of attention and probably a lot of controversy. I do want to note that the smaller number of cases that they have accepted suggests that they may be trying to leave a little bit of room on their docket for election litigation, which is going to come in pretty quickly and take up their time. There are also these other cases that are kind of waiting in the wings that might come up. But one thing that you might want to pay attention to that isn't going to necessarily make it onto the front page of your favorite newspaper or the banner headline on your favorite news website is what the court can do by not acting. There are a few circuits, the Fifth Circuit in particular, where you have some judges that are making some decisions that are really trying to push pretty hard in a conservative direction. And the court will have choices about which of these rulings it is going to allow to stand and which it is going to take on to question, perhaps adjust, perhaps reverse, and then what the timing of those kinds of decisions will be. So that is certainly something to keep an eye on. The court is also creating some news that is about things happening outside the courtroom, right? If you are interested in a deeper dive into the ethics issue around the Supreme Court, I can put in a quick plug for a panel that's taking place this Sunday, hosted by Rockefeller College and the Museum of Political Corruption. They're giving an award to ProPublica for their outstanding reporting on some of the ethics questions that have come up about the behaviors of some of the justices. As you know, there's been a lot of press coverage about Justices Alito and Thomas in particular, and their connections with right-wing interests and the largesse that they have received from these interests that continues to attract attention and controversy. Over the summer, the Judicial Conference actually pulled back a little bit on what looked to many legal observers to be a fairly mild set of ethics standards that were put forward last year. So they've suggested that Supreme Court justices should be allowed to keep private vacations out of the public eye. So you are not entitled to know where Justice Thomas flies when he is on a private jet funded by Leonard Leo. And this is actually seems to be creating not just controversy in the broader public sphere, but some tension within the court itself. I've got kind of an extraordinary factoid here, which is that Elena Kagan has given a couple of addresses in which she is basically overtly politicking for an enforceable ethics code, which is kind of remarkable to see. I would argue that Justice Roberts still sees himself as an institutionalist, regardless of what the punditry may be saying about his efforts to remain in that space. There's been some excellent reporting by Joan Biskupic in CNN about the kind of the fallout from the 2023 term. One of the things she noted is that Roberts seems to be genuinely confused by the negative reaction to the court's ruling on Trump's immunity. He had believed that he was creating a decision that would protect future presidents, but also provide a clear set of guidelines under which the Trump case could proceed. For many people, of course, that's not how it landed, including some members of the Supreme Court. But one of the things we now know about that immunity decision is that much of the struggle over Trump immunity was not between the conservative justices, the 6 conservative justices, and the 3 liberal justices, but rather among that conservative bloc and between the hardliners who really wanted to immunize Trump almost completely, and the more centrist conservatives who seem to have largely prevailed, producing the opinion that we saw there. And I would expect, we're going to be seeing more of those kinds of dynamics this term, which has been a feature for the last couple of years. Some might say that the court is in a legitimacy crisis right now. It's probably fair to say that they're close to a legitimacy crisis, even if they are not in one. They are at a very low, possibly a historically low general approval rating. The court always used to be pretty resilient. Whenever people were talking about how much they hated government and didn't trust government, you could see that the president got low ratings and Congress's ratings were in the toilet. But the court's ratings often kind of held up there. People would be willing to say, maybe I don't like everything that the court's doing, but I trust it as an institution. That's really been undermined significantly in the last few years. I think it is now probably safe to say that Dobbs had a lasting impact on people's view of the court, both in terms of their agreement with the decisions that the court is making and their perception of the court as a political actor. And there's a major split in the way that people who lean Democratic view the court versus the way that people who lean Republican view the court. Among Republicans, you're going to see a little bit more trust in the court right now. I would say until pretty recently, the threat of court curbing has seemed pretty distant to the justices if we can judge based on the behaviors that they have been undertaking. Right now, we're seeing some proposals go forward. You have the Wyden proposal to increase the size of the court. There's some talk about term limits. There's continued talk about the possibility of some kind of ethics code. So, a lot of these kinds of things are being discussed. And but it's hard to tell exactly where that's going to go. And certainly some of the justices on the court have continued to be pretty impervious to these kinds of signals, suggesting that they don't believe that there's any serious threat to curb the power of the court. So if you're, if I can engage a little bit of mind reading to the extent that this is possible, if I'm John Roberts, what am I going to do this term? And there's really a choice. Does the conservative majority on the court continue to swing for the fences? Let's try to get everything that we can while we've got this majority. Let's overturn the New Deal civil rights order and develop a new order to put in its place, putting the courts in the driver's seat to manage this process going forward? Or do you be a little bit more careful? Do you look over your shoulder and say, looks like there are some serious efforts toward court reform that could change the power of the institution itself on the horizon and kind of hold back on some decisions that might seem to be more controversial? I would argue that that is likely what happened with the case involving the conflict between the federal statute on emergency health care for women and the Idaho anti-abortion statute. And you see that the court declined to grant emergency petitions, curbing the power of the EPA just recently. But a lot of that, I think, is going to, the court is likely to hold off on anything really major until we get to the election, to the extent that they can, right? There may be things that they cannot duck as the election is coming up, especially if these are questions that have to be resolved around voting access and voting rights. So the things that you want to be keeping an eye on as we go forward to the election and beyond, what's going to happen with that 6-3 split? Are we going to continue to see tension between the hardline conservatives on the court and this kind of middle conservative group that seems to be coalescing? Amy Coney Barrett is certainly going to be worth watching this term. She seems to be indicating here and there that she's not aligning with that really hard right cohort on the court. And there have been a few instances where she seemed to provide some kind of tempering influence on what the court is doing. Is Roberts going to be able to create and hold a center on the court? Is that what he wants to do? I think we won't be able to know the answer to that question until after the election. We see where the court winds up, where the election winds up. But most importantly, I'm sure John Roberts is asking himself, what does this court have to do to stave off any attempts at court curbing? And the most important component here is something that really is not directly under his control, which is the outcome of the 2024 election. If we see Trump take office again, and particularly if Trump has a Republican Congress, then that hardcore conservative wing of the court will likely be empowered to go as far as they want to both tear down the New Deal civil rights order and develop and put into place a new, more conservative order that again is under the control of the courts. If alternatively the election goes all the way the other way, then the center justices on the court will probably have to be more concerned about possible political attempts to control the court. And we may see them moderate their decision making in order to stave off those efforts. So that is, I think, the best I can do to sort out what we can see on the horizon, keeping in mind that over the last few terms, things have happened that have drawn the court into political controversies that weren't necessarily foreseeable in early October. So I am now ready to try to respond to any questions you might have about what's going on with the court this term.
And for those who've just joined us, you can put your questions in the chat. You can raise your hand. Let's see, I can get us started with one, just expanding on some of your comments, Dr. Novkov, on the court's public perceptions. Is there any sort of action, I guess, Roberts or any member of the court can take to mitigate these declining public perceptions? Could that be embracing some ethics package? Should it be, as you've put it, to not swing for the fences on every case? Or is this just going to be a permanent feature of our political system where the approval rating revolves around some low number in like the 30s or something like that? What do you think?
I think there are actions the court could take to try to shore up the perception of their legitimacy. And I think you're right. Really, the two biggest things that they can do would be to adopt an ethics code, as Elena Kagan has suggested. They're probably better off designing and adopting one themselves than having one imposed on them by Congress. But they can also think about what cases are they going to take and how are they going to rule in those cases. I would expect, as they're waiting to see what's going to happen, they may not be as inclined to take cases that have the potential to create a lot of controversy, but sometimes they just can't avoid it. That these things come forward, they have to produce a decision. And in that sort of situation, it really is this question: do they go all the way out there, as they did with Dobbs, overturning Roe versus Wade, or do they try to resolve cases in ways that may achieve the objectives that the conservatives want while not creating the giant headlines? That was the route that Roberts would have preferred in Dobbs, but he was not able to win that one.
All right. Yeah, thank you for answering. It's always a fun question. Continuing our tradition of optimism here in the Rockefeller College election series. Looks like we have a question from Michael Klein in the chat. He wants to know, do we expect a vacancy on the court over the next 4 years to be filled by the next president? What do you think, Dr. Novkov?
I think it's pretty likely that no matter who wins, there will be at least one vacancy. Some of this is going to depend on who wins. If former President Trump were to win the election, I think it is entirely plausible that we would see both Alito and Thomas leave the court when there is a good opportunity for Trump to elevate two more very young, very conservative justices in the mold of Justice Gorsuch. If Harris were to win, and if she were to have a Democratic Senate, there's been some speculation that Justice Sonia Sotomayor might decide to retire, again, strategically giving Harris the opportunity to put a young liberal justice on the court. Beyond that, I think it's a little hard to tell what might happen. We need to remember that this court right now is quite young. If Harris were to win, it is very likely that Alito and Thomas will try to hold on for as long as they need to hold on in order to wait it out and be replaced when a Republican is in office. So overall, unless something unexpected happens, it seems like it's pretty unlikely for the election itself to change the ideological makeup of the court.
All right, it looks like we have a question now from Renee. So she asks, regarding what you said about a legitimacy crisis and the courts getting involved in political controversies, do you think what is happening now is unique, or have there been other similar circumstances in the court's history?
Well, again, the court sometimes can't avoid getting involved in political controversies. This goes actually all the way back to that case that just about everybody has heard of, Marbury versus Madison. If you're talking about conflicts of interest, what do you think about a Supreme Court Chief Justice who was the Secretary of State and involved in the actual controversy? Because that is the scenario for Marbury versus Madison. John Marshall was the Secretary of State and a staunch Federalist. So yeah, these things have happened before. Sometimes the court will reach out and try to resolve a national controversy and believe that if they kind of go big on resolving a national controversy, they can quell political conflict. Often this doesn't work out well. Some of the major examples of this would be Dred Scott, which was Roger Taney's famous attempt to settle the problem of slavery, which the political branches had been unable to resolve. Plessy versus Ferguson was kind of the capstone to an era of political conflict and political controversy, which opened up the possibility of political peace by empowering the Southern states to put into place state level regulations that produce Jim Crow. The Warren Court hoped to resolve controversy over segregation and built up over time to decide Brown versus Board of Education. That case was extremely controversial when it was decided, and then the court itself, of course, continued to render decisions that were politically controversial. One thing people don't necessarily remember about the Warren Court is that some of their decisions in the mid-1950s, particularly those that protected freedom of speech, including freedom of speech for communists, produced a very strong political backlash against that court. And in fact, if you look at what the court was doing in the late 1950s, they did pull back on that agenda, and they were not as willing to issue these broad protections of freedom of speech for communists. This one is a bit unusual, this current moment, because not just because the court is divided or because they're wading into controversial political areas, but we're seeing a divide on the court that is not just ideological, but where you have justices that are aligning in partisan ways. So one court I like to talk about is the Fuller Court in the late 19th, early 20th century. Very conservative court, did a lot to empower Jim Crow, did a lot to uphold immigration restrictions. But those justices were not falling out on partisan lines as we see the Roberts Court doing.
All right, it looks like we have another question in the meeting chat from Eugene Monaco. He asks, what's your opinion regarding term limits for the Supreme Court? Is it a realistic outcome? Always a fun question.
Yes. So is there a way you can design a statute that would impose term limits on the justices that would comport with constitutional standards? A lot of legal scholars have noted that while Article 3 does establish the idea of life tenure for the Supreme Court, it does empower Congress to establish the lower federal courts and gives them a lot of authority over the courts, over the federal courts generally. And this is something that was underlined by John Marshall in Marbury versus Madison. So the theory goes, one theory about this is that, okay, a president can appoint and the Senate can confirm somebody to a Supreme Court seat, and that person may have permanent appointment to federal courts. But there's nothing in the Constitution that requires that justice to remain an active Supreme Court justice. So you could say, well, if they're required to take senior status, they're still a federal judge. They haven't had that appointment removed, so it's constitutionally okay. But you can then appoint another justice to be a regular justice on the court. The other idea that I've seen floated around is, well, you know, maybe they have a permanent appointment as a federal judge, but they could be shifted to the DC Circuit. There's nothing in the Constitution that says that once you're appointed to a federal judicial position that you can't be moved around. The thing to keep in mind about all of these proposals is that Congress will do what Congress wants to do. Supreme Court reform presumes that you have a Democratic House, a Democratic Senate, and a Democratic president right now. But anything they do is going to be subject to legal challenge. And guess who gets to decide whether such statutes would be constitutional? I suspect the Roberts Court is not going to be very appreciative of efforts to impose term limits.
All right, thank you for that. Looks like we have, oh, it's a long one here, Dr. Ingram. Oh, okay. Looking back over the last few years, the court appears to be giving itself more power in different ways, either by choosing to decide cases that are not quite ready to be decided by the highest court, by developing new ideas about how cases should be decided, e.g. major questions doctrine, whereby say erasing Chevron deference and making themselves de facto experts and final interpreters of legislation? Do you see this happening in other ways? Will this trend continue, and what are larger implications?
That's a great question, and I thank you for asking it, because this is one of those things, again, doesn't grab headlines, isn't something that's very much on the public's radar screen, but it is a really important and I would argue worrisome development on the court. As the question poses, the court has been increasingly reaching in to decide cases or direct the path that they're going to take before they've gone through the normal process of deliberation and final decision at the district and circuit court levels. And we've seen the court, particularly with regard to the administrative state, saying, we, the courts, are the experts. We're going to be going in and checking what administrative agencies are doing and making decisions about how far federal rules promulgated by administrative agencies can go, even to the point of putting themselves over expert guidance that's coming out of those agencies. But yeah, that's not the only place where we're seeing what I believe to be as intentional efforts on the part of the Supreme Court to empower itself and to empower the lower federal courts. The other major area where this is happening is with regard to elections and election law. Some of this is with the court reaching in. Some of it is looking at, what the Justice Department can and cannot do. But if we look at the case where the independent state legislatures theory was put forward, a lot of people were really worried about this. Oh my gosh, the court is going to set up a situation where state legislatures could overturn rules based on the constitutional allocation of that power to state legislatures. The court backed off of that, and there was sort of a sigh of relief among many experts. However, one of the things the court did was it put the courts in the positions, the federal courts in the positions of being the final arbiters over whether practices that the state put into place were going to comport with the constitutional standards that the courts themselves are defining. And that's the kind of move I think we need to be watching for, both when they're dealing with a question that's exclusively at the federal level and a question that's taking place at the state level. Where are they saying, okay, we're allocating this power to this institution, but we're holding in reserve the idea that the courts are going to be the ones who have the final degree of oversight over what happens. And the way that this is set up, right, it's almost like a one-way ratchet. It's very difficult to figure out how you ratchet that back without significant congressional intervention and reform.
All right, well, we still have about 15 minutes here. While we wait for more questions, I'm curious, you mentioned the partisan alignment of the Supreme Court. I don't know if this is your experience, but when I talk to undergraduates about the court in the post-Dobbs era, they're like, oh, it's all just 6-3 decisions, the conservative supermajority. Are there any publicly visible or high salience cases you anticipate this term that will not be decided along 6-3 lines?
I imagine we'll see plenty of rulings that are not 6-3, or rulings where it may be 6-3, but not necessarily the 6-3 that you expect it to be. So the justices that you want to watch in cases that do have a kind of clear political valence, is Justice Roberts going to be able to pull in a centrist, a conservative center judge, a conservative centrist justice to collaborate with the liberals on the court, producing a 5-4 decision in a more liberal direction. You may occasionally see a sort of conservative center coalition coming together, where you may have a couple of justices objecting on the right and a justice objecting on the left. Ketanji Brown Jackson, because of her interest in originalism and some of her practices of statutory interpretation, can sometimes go in a direction you wouldn't expect. She did that in the Fisher case about January 6th defendants and the extent of that statute. And Amy Coney Barrett, I think, is definitely one to watch. There was a case last term where you had a 5-4 case, but it was the 4 women who ended up on the losing side of that one. And Justice Gorsuch can sometimes take up the standard of criminal defendants' rights. And he is a very, very reliable vote for Native American sovereignty. You are always going to see him, I think, out there pushing hard on expanding Native American sovereignty. Whether he can carry the court with him or if he's going to stand all by himself, that's where he's going to stand.
All right, great. Thank you. Maybe there is hope for us all after all. We have a question from Natalie Johnson in the chat. She asks, following up on Matt's question, does this idea of learning in show that the court is not so much restrained, but more activist now even for conservative justices? In some way, since the court has control over its docket, is the court bringing this legitimacy crisis and involvement in politics upon itself? Leaning in, yeah.
I suspect if you ask this question of Elena Kagan, she would say, well, duh. She's been pretty vocal about what's going on with the court right now. But yeah, again, I try to think about it. If we take Justice Roberts at his word that he wants to be an institutionalist, he wants to preserve the legitimacy of the court. A lot of the problem is that you've got some people on the court who are really just devoted to pushing forward their agenda. And they seem to believe that there really isn't much they can do that is going to provoke enough public support for court curbing that they need to pull back. So Thomas has continued to accept largesse from conservative outlets. Samuel Alito has continued to accept largesse from conservative outlets. We have not seen conservatives on the court agree to recuse themselves in cases where they have some connection to what's been going on in the case. In the Fisher case in particular, right, that was the one about the use of statutes to charge January 6th defendants. Given Martha Alito's connections to some of those who were involved in January 6th, there was some discussion that perhaps Alito should have recused. We now hear from Joan Biskupic that Alito may have been the original opinion, had the original opinion assignment in that case, but then the news broke that they'd been flying this insurrection flag. And apparently the opinion then shifted to Justice Roberts. So there's some recognition that, yeah, the optics matter, but that recognition doesn't seem to be curbing the behavior of all of the justices on the court.
All right, well, do we have any other questions here? Last call. If not, we can end a little bit early today. See, I'm just going to go through the hand raising. All right. Well, thank you so much today, Dr. Novkov, for your presentation on the Supreme Court. And thank you to everybody who asked questions and participated, who attended and spent their lunch with us today.
I think we have one more from Professor Osal.
Oh, right. Is there? Okay.
What should we be most worried about?
What should we be most worried about?
I always ask the awful questions.
I think we should be most worried about John Roberts being overconfident about the court's level of empowerment. What do I mean by this? I believe that given the experience of the 2020 election and the firm pushback on election denialism that the federal courts administered to the Trump campaign, that Roberts believes that he and the other justices on the court can manage the process should the Republicans end up heading toward a second Trump term and perhaps a Republican Congress. So you might see them here and there putting a little bit of a thumb on the scale to push the election in that way. We can spin out any number of crazy scenarios that put us back into a Bush versus Gore situation where the court is making a decision that has a very large impact on the outcome of the election. And were that to happen, one could imagine Roberts and the conservatives saying, okay, we're going to put that thumb on the scale. We're going to reinstall Trump as president. And that's going to be fine because we're right here to make sure things don't go totally off the rails. I think that that would be a really critical mistake on the part of Roberts and the court to believe that their empowerment can enable them to keep the potential worst impulses of a second Trump presidency under control.
Thank you.
All right, awesome. Well, I think that's a good question that gives us a lot to think about going into this term. Again, thank you, Dr. Novkov, and thank you everyone for asking questions and spending your lunch with us today. Our next meeting is going to be on October 17th, 12 to 1 on Zoom, and we're going to talk about some criminal justice policy. So it's going to be a fun time as always. Thank you, everyone.
Thanks, everyone.